Hello, everyone, and welcome to Mountain States Legal Foundation's Constitution Day webinar, where we will be discussing the forgotten framers and their influence on the Constitution. For those of you who have never joined us before, Mountain States Legal Foundation is a nonprofit legal foundation founded in 1977 and dedicated to protecting individual liberty, the right to own and use property, the benefits of the free enterprise system. Joining me today, first of all, I'm David McDonald. I'm one of the attorneys at Mountain States Legal Foundation. I'm joined by my colleagues, Cody Wisniewski and Brian Gregg. Happy Constitution Day, gentlemen.
Happy Constitution Day.
Oh, in unison.
Yeah, that was great. Starting off really great. So this is September 17th, 133 years ago today.
233 years ago.
That's the second time I've done that. 233 years ago today, the Constitution was signed in Philadelphia on a hot September day. But as all you know, we celebrate our birthday of this fine country on July 4th. In fact, a lot of people tend to forget that we were actually operating under a completely different governmental system for more than a decade before the Constitution was ratified. So it's really a sort of, the Constitution is really Constitution 2.0, if anything. Cody, you're a dirty anti-federalist. Why don't you tell us a little bit about Constitution 1.0?
Thank you so much. So what David's talking about are kind of the oft-forgotten articles, the Articles of Confederation. And that is what our country existed under prior to the Constitution. So it was a very short document. They were very loose, and it established, my favorite quote from it is, a firm friendship amongst the states. I can't think of another country that is founded on a firm friendship, but I thoroughly enjoyed it. However, there were a number of issues with the articles, and eventually those issues became so important enough that we got America 2.0 just 12, 13 years later.
Yeah, and as everyone is taught in school, that's James Madison is the father of the Constitution. He rode in on a white horse one day and bequeathed us to this document, right? That's how we got it. But really, in actuality, if you look at the Constitutional Convention, it's a little bit more complicated than that. In fact, there were a lot of men there who were actually very influential that we've largely forgotten about. We remember Hamilton, Madison, John Adams, Thomas Jefferson, who wasn't even at the convention, neither was Adams. But we've almost completely forgotten about other giants in their day, like George Mason, Gouverneur Morris, Elbridge Gerry. These are gentlemen who have had an extreme sounds bad, had a profound influence on both the American Constitution and the larger American Republic, which I think is really interesting because that goes into the fact that the Constitution isn't some quasi-religious document. This is something that was the product of compromise, sometimes a messy compromise, between 54 delegates who were present in Philadelphia at the time. So I think that brings us to the topic of today's discussion, which is these forgotten framers, one of which I think is George Mason. Why don't you talk to us about George Mason a little bit?
Yeah, and I think that's the beauty of this, right, is when you're talking about this document as a document of compromise, it's a lot of brilliant people at the time getting together and debating these ideas and talking about what this document is going to look like in 233 years and debating that. And one of those gentlemen is George Mason. And I don't think you can really talk about George Mason without also talking about Patrick Henry. And these are two guys that get both from Virginia that kind of get, or at least were pushed under in the conversation for quite a while. So, Patrick Henry participated in the Continental Congress, which was what was acting under those Articles of Confederation. And George Mason refused to. He stayed in Virginia and was part of the House system there. But they actually swap once we get to the Constitution. So famously, Virginia tries to send Patrick Henry to the Constitutional Convention, which occurs next. And Patrick Henry was concerned about the government that was going to be created and was concerned about a very strong federal government, something that we're very aware of today. And famously said, "I smell a rat," or at least I hope he actually said it. I haven't seen a good corroborating.
Technically apocryphal, but let's go with it. That's
strongly implied, right?
Yeah. So he doesn't go, and George Mason actually does go to the Constitutional Convention. And George Mason's concern, while he gets labeled as an anti-federalist, it's really a different kind of anti-federalist. And I think this is important because...
Actually, what I think we should probably real quick, I don't want to interrupt you there, but real quick, Federalist versus anti-federalist. At the time of founding of the country, first of all, you have the Federalists versus the anti-federalists in the run-up to the American Revolution, which was the Federalists are those who supported national government fighting against Great Britain, those who were... and then the anti-federalists who weren't as aggressive about that. And then once you get to the Constitution and immediately after the Constitution, they've kind of coalesced into what eventually became the two first main political parties. You have the strong central government federalists and the strong state government anti-federalists.
Exactly.
Overgeneralized, but that's basically the situation we're dealing with here.
And that's where Mason comes in, right? He was really concerned, as we are, about having a very strong, all-powerful central federal government. So his voice at the Constitutional Convention is very important for us today, because what he was consistently advocating for was bounds on federal power and less federal control of certain things. Remember, he wrote the Virginia Declaration of Rights, which was adopted later on by Virginia in a slightly different version, but was also basically stolen for our federal Bill of Rights. And his concern and his voice consistently at this convention was reining in the federal government, ensuring that the provisions that were in the Constitution weren't so broad that the federal government could grab its own power. And, I can't help but wonder, so I know that he had a great effect on the document as we have it today, but I almost can't help but wondering if he was more of a louder voice, if we could have had a more constrained constitution even, that would have prevented some of the federal government overreach that we had today. I mean, the framers couldn't have possibly imagined the government as we have it today, but, I can't help but wonder, alternative history, if there is a way that we could have even kind of bumpered it in even more.
Mm-hmm. So I would say, would you describe George Mason as kind of one of the losers of the convention? That sounds really bad, but...
No, I don't think so. I think George Mason was fairly successful. I think also after the Constitution, he's pretty successful in getting a Bill of Rights that tries to kind of rein in the federal government in some way. He really did want provisions in the Bill of Rights that would put bumpers on the federal government, not just identify individual rights. So I think he was successful. And I really do think that without him, the Constitution could have had certain provisions in it from other voices at the convention that would have made it a little bit easier for the federal government to expand its power.
Mm-hmm. And speaking of the gentleman who refused to sign, George Mason was famously one of three. One of the other three actually was Elbridge Gerry, someone who perhaps doesn't have a big university named after him, but has other fun things named after him.
He does. So he's like, who the heck is Elbridge Gerry? Is he some character from Downton Abbey? No. You probably know him best as being the namesake of the word gerrymandering. And Gary got converted to Jerry through the course of history. I don't know how, but that silly term, as I think everybody knows, refers to the process of drawing peculiar-looking districts for legislative purposes in terms of who gets to elect what. And that name was coined by a Federalist cartoon back in the day, basically lampooning what they thought was a salamander-looking kind of shape that Essex County, Massachusetts had been forced into because of some redistricting. So that's kind of his biggest claim to fame. But really, if you look into who Elbridge Gerry was, he was the 5th Vice President of the United States. He was the governor of Massachusetts, and he signed the Declaration of Independence. But as David just said, he was one of 3 other people who did not sign the Constitution. The primary reason being that it did not contain a Bill of Rights. That was the huge bone of contention between the Anti-Federalists and the Federalists, and the ultimate inclusion of the Bill of Rights mollified a lot of the anti-federal sentiment, but it still, it didn't fix everything, obviously, and a lot of the points that they were complaining about, I think, were frankly vindicated in a lot of respects through the course of American history. So, Elbridge Gerry, I think, deserves a lot of recognition exactly for the same reasons why Cody was talking about George Mason. But one of the reasons why Elbridge Gerry stands out to me is that think back to when you were in 7th grade and you're learning about civics and the 3 branches of governments and how a bill becomes law, that kind of stuff. Well, honestly, a lot of that process, that machinery of the Constitution, so to speak, was the product of Elbridge Gerry. And he did support federalism, but he wasn't enough of a federalist for the Federalist liking, basically. He was a radical centrist. So, for instance, he didn't want a standing army. He thought that was a path to tyranny. At the same time, he also wanted impeachment provisions for the executive, because people assumed that George Washington was going to become president, but some people went so far as to assume he would become a monarch on one very far extreme. So in most cases, he was always advocating for a very moderate sort of compromise between 2 very extreme portions that often deadlocked the initial Continental Congress.
Interesting.
One of the things that I always wonder with him is, do you think that we come to this document that everybody does agree to sign and eventually gets ratified once they add the Bill of Rights without his voice? I mean, he really is a agent of compromise, but in a good sense. I know that we hear that now when we think of bad things,
Right.
But at the time, you're have this kind of loose handful of states that you're trying to meld together into a nation. There's another conflict that's happening or about to start. So, do you think that we get this kind of unified constitution without his voice in the
No,
convention?
not at all, because he was key. And actually, if you look at just the number of speeches that he made, I believe that he was second only to Madison in terms of the amount of speaking he did.
Second to Gouverneur Morris.
Second to Gouverneur Morris. I get them mixed up,
Don't we all, Madison, Gouverneur Morris?
Speaking of Gouverneur Morris, this is the gentleman I've decided to talk about today. He's sort of almost diametrically opposed to the Patrick Henrys of the world, in which he was an arch centralist. He was a big fan of strong central authority, was one of the big kind of advocates for strong central executive. I tend to see him as sort of the anti-Jefferson, not in an evil way so much as a sort of a photo negative way. In that Jefferson is famously the we should be a country of yeoman farmers, and where every single man is his own king on his own little piece of land. Gouverneur Morris was very much part of the New England, or New York technically, New York mercantile elite, very aristocratic bearing. He's very much pro that. So he's, as opposed to Jefferson there, he's very commercial interest. He's very centralist opposed to Jefferson. He absolutely was disgusted by the French Revolution in every possible way. Meanwhile, Jefferson was a famous proponent of it. And also he's one of the biggest opponents of slavery at the convention, which, as we all know, is Jefferson's greatest flaw. And while some of the other people at the Constitutional Convention are lesser known because they've perhaps lost out in some of the debates of history, Morris is left out almost, you think, by design, in that he engaged in what I like to describe as the most influential style edit in the history of human civilization. As the head of the committee of style, that once Madison and the rest of the convention had figured out the provisions, what they wanted to have in the Constitution, they sent it to a 5-person committee of style that was supposed to make the language look nice and pretty and flow well and be something that people would want to read. And during this process, again, very late in the convention, once everyone was kind of tired of things, something that's really come to light, especially recently. I think there's a really great article. William Traynor, the dean of Georgetown Law School, has a forthcoming article about this, which I encourage everyone to look up. But this style committee actually made a lot of substantive changes to the Constitution, which we'll talk about in a moment here. And I think that's really fascinating in that, in many ways, the Constitution that the framers voted on and agreed to wasn't the same Constitution that was eventually ratified by the states. And that's something, at least for me as a constitutional litigator, I didn't know that until fairly recently. And I think that was really eye-opening to me, at least.
Absolutely.
Yeah, when you think of style committees, right, you're thinking of I mean, punctuation would have been very helpful in a number of contexts that I practice law.
Exclamation points.
Yeah. Or commas. Let's get rid of some commas now. So you're thinking of things like punctuation, spelling, grammar. When I give you guys a draft of a brief and I ask for a quick edit on it, I don't expect you guys to rewrite paragraphs or to change clauses that enter into arguments. And that's kind of what the committee did. Not incredibly overtly, not in all the scenarios. Most of the edits, from what I've seen, are more minor, but some of them have a fairly big bearing on the conversation.
Right. And that's really kind of the heart of what I wanted to talk about today is the subtle little things that Morris especially went after. I keep saying Morris, Gouverneur Morris. Worst name, if not necessarily the worst founder.
At least the hardest to pronounce.
So I think this is most clear. You can see his influence is you look in what are known as the vesting clauses. So the Constitution, if we remember back to our high school civics classes, there are basically three main articles. The legislative branch is in Article 1, that's Congress. The executive branch is in Article 2, that's the president. And the judicial branch is in Article 3, that's the Supreme Court and the lower courts. If you look, originally the way this was written was there were 10, 11 articles in the original Constitution, and they all had fairly similar wording. It was the legislative power of the United States, the executive power of the United States, the judicial power of the United States shall be vested in a certain person. So what Morris did was he went and he took the executive branch's clause, which originally said, the executive power of the United States shall be vested in one person, a president of the United States. Originally constituted, this was primarily a way of showing that the president should be a single individual rather than a team of people. That was something that was actually under a lot of debate at the convention, was should the president be a single person? Many people were very concerned that would devolve into a monarchy. So there were ideas about two presidents, like the Roman consuls. I think there was even a committee of 5 at one point that was thrown around. So originally it had one president, so it was stating there was a single person. It said the executive power of the United States. So it means that those executive authorities given in the United States. What Gouverneur Morris did in Article 2, Section 1, was he changed it very, very subtly to the executive power shall be vested in a president of the United States. Now, this doesn't seem to be a significant change until you really look at it. And you see that one, it says take out of the United States. It went from the executive power of the United States to the executive power. This seems like a small stylistic change, but if you're familiar with the legal landscape at the time these people were writing, by doing that, what Morris was doing was claiming executive authority under the old English common law system, the executive authority of the king. So there were many people who were not prosing. I think George Mason was one of them. Elbridge Gerry, I think, might have been one. I don't recall if he made this comment about this. But people have said explicitly that no, we're trying to avoid a monarchical system. We don't want the president to have all authority incident to the power of the crown. He is supposed to be an administrator for Congress's actions. So by taking that out, it implies a broad grant of authority that is not present in Article 1 or in Article 3.
Because it doesn't say, because Article 1 has herein granted.
Article 1 says all the legislative power herein granted. And likewise, Article 3 carries the original Article 2 language, is the judicial power of the United States. Mm-hmm. So if you look, the other two branches are limited to that explicitly granted authority, while the executive branch is, at least in theory, you can read this, and that's how it has been read over the years, to say that it's expansive.
And bear in mind that 200 years after all this happened, we live with this gigantic behemoth of an administrative state, which falls under the executive branch. So right. That's not an accident.
Right. So by changing that, and then by changing it to rather than saying one president, just saying a president, it changes the focus. So which is also important because it stops being a clause describing the individual who is going to be president of the United States, and now it becomes an explication of executive power, which that's a massive difference, and that's something that whether you can argue back and forth, and some people have that, well, this is a stylistic change. It doesn't actually change the content of the Constitution. except for the fact that what it does is it provides cover for those who want to argue for a more expansive executive authority.
Well, this is interesting too, because so under the Articles of Confederation, the president was much more of a parliamentarian, right? So the president under the Articles was selected by the representatives of the state. So the states could send however many delegates they wanted, but they had one actual voting delegate, and that they would pick the president from amongst themselves, and that person would operate much more like the Speaker of the House than they would as
more like a parliamentary system.
Yeah, so they're coming from the system where there is no real single person, and there's a lot of issues that, particularly Washington raises. He kind of gets brought into the conversation because he experienced all the problems during the Revolution of, feeding and clothing an army and getting supplies. And that's one of the things that he talks about is without having that kind of executive power, that it made it very difficult for them to win. I mean, it's kind of a miracle they won the Revolution, as anybody who, when you dig into it, you start to learn. But
thank you to the French.
It's a really big shift that you see. And I think it's partly in reaction to the utter lack of an executive. And I wonder if that's a big factor in the big push the other way.
Interesting.
That certainly was one of the reasons why Gary in particular argued against having Congress choose who was president. There was a big bone of contention, but at the same time, like I mentioned earlier, he also balanced the unitary executive with the impeachment power. And his reasoning was that if you're a good president, you have nothing to fear. And if you're a bad one, you should definitely be afraid of something.
Right. And that's something I thought was really interesting, was the fact that we now take the co-equal branches of government, the tripartite division of power of government. This is something literally every single American student is taught. Literally, maybe strong. Most of us are taught in school the co-equal branches of government. That phrase, that doesn't really come up in the Constitution.
Mm-hmm.
We get that from the structure of the Constitution, which again was actually a later invention that came very late in the process and was seen at the time largely stylistically. And we only really came to find the structure of that being meaningful in a substantive way somewhat later. And I think that's really interesting, is you can see the way in which the Constitution is written really makes a big difference in how it's actually interpreted later on.
For example, there was a proposal that the executive and the judicial branch were to have some sort of review committee to look over final laws that Congress had passed. And that was one of the things that Gary, I know, struck down, among others. But this idea of balance of power is like, well, that was exactly what was being debated 200 some years ago. And so what we take for granted today was actually very ambiguous at the time.
This all brings me very nicely to the provisions I want to talk about, both from inappropriate education today, as well as forgetting the fourth article, right? The fourth article of the Constitution is all about the states. So, we talk about the three branches, Article 1, 2, and 3, and we talk about them creating the federal government, but Article 4 was just as important to the framers. I mean, that was where you get this, construction of state power. Before I move on, we should remind people that, as we get towards the end, there will be Q&A available. So there's a Q&A button at the bottom of your screen. Feel free to click on that. Go ahead and submit questions as we go. We'll stop talking at some point, I promise, and we'll start answering questions. But that time is not now. And one of the good edits that Gouverneur made was to what we call the Fugitive Slave Clause, and that's in Article 4. Now, just to set the stage here, so I'm going to talk about a couple of different instances in the Constitution where people have tried to argue that the Constitution endorses the idea of slavery, and that could not be further from the truth. If you look at these articles and you look at the debates, you understand that the founders and framers hated the institution of slavery, most of them, and did everything that they could to get rid of it. So when I talk about a lack of education, I'm talking about things like the 1619 Project. This idea that we were founded on an institution of slavery could not be further from the truth. And Gouverneur Morris is a really good example of this. So in Article 4, and I actually brought my Constitution just so that I could have the text with us. So the Fugitive Slave Clause reads, "No person held to service or labor in one state under the laws thereof, escaping into another, shall in consequence of any law or regulation therein be discharged from such service or labor, but shall be delivered upon claim of the party to whom such service or labor may be due." So essentially, what they were trying to say is the southern states were really adamant about this. And the idea is they didn't want slaves escaping to northern free states and then immediately having a claim to freedom. But that clause actually used to have the word justly in it. And it originally said, but shall be delivered up to the person justly claiming their service. And Gouverneur Morris explicitly altered this clause and deletes that word justly because he had no interest in the Constitution in any way, shape, or form, considering the institution of slavery to be just. So, he might have created a slightly larger federal government, but he also helped stylistically rein the Constitution in to ensure that under our Constitution, the institution of slavery was never endorsed, and quite the opposite, was actually weighed against. Mm-hmm. And then that brings me to the next one, which is the Atlantic slave trade. I think that this is really interesting by its location. So it's in Article 1, Section 9. Now, Section 9 is the list of things that Congress can't do. Section 8 gives Congress all its powers. That's the powers herein granted, the actual ones, not just kind of the procedural or elective ones. And Section 9 is the opposite. It tells them they can't do what they can't do. And Clause 1 is the migration or importation of such persons as any of the states now existing shall think proper to admit, again, not endorsing, shall think proper, shall not be prohibited by Congress prior to the year 1808. Meaning, as soon as the year 1808 rolls around, Congress can prohibit the importation of persons. Congress can stop the slave trade. Do you want to know what happened in January of 1808?
Tell us.
Congress prohibited the slave trade. Literally the first day that they were able to under the Constitution, they did. And these are things that people forget about these articles. People forget that they put in everything that they could into the Constitution to placate some of the South that was going to refuse to join and was going to go into war immediately in 1790 in order to ensure that we had a country that could stand and that we could get rid of slavery faster than any other country to ever exist in the history of our world. I mean, the institution of slavery lasted under 100 years in the United States, and that is by far the fastest of any nation.
Mm-hmm. And I think that's really interesting too, because this is a debate that's been going on, not just amongst current Americans now trying to argue current battles over the past. This is an argument between the pro-slavery South and, say, Frederick Douglass and other abolitionists in the North at the time. So this is, if you look at newspapers from the 1850s, this is a very massive debate going on about whether the Constitution forbids slavery, whether it endorses it, whether it's silent on it. I think that's a lovely way if you want a primer in sort of early American argumentation. And so what does America mean, the soul of America? I think no one's ever really said it quite as eloquently as Frederick Douglass did.
I think that's absolutely right. And I think it's really important. I know we got serious, but it is really important to reject this idea that somehow slavery was inherent in our system. I mean, that just can't, it's just couldn't be further from the truth. And these few articles add to that conversation. I mean, we all recognize that the Constitution or the Declaration never uses the word slavery, but a lot of people try to argue it was built on that foundation. And that's just not true. I mean, you see these delegations, you see these different groups of founders and framers at the Constitutional Convention whittling away at the institution as fast as they possibly can. Now, the last one is the 3/5 clause. Now, this is in Article 1, Section 1, Clause 3, and this talks about how the Congress is going to apportion members of the House. So remember, the House members are all decided by population. I mean, that's still true today. After the census, they always reassign House members. But what you also have to remember is at the time, there's a large amount of slaves living in the South. Now, as soon as the South heard that the House was going to be apportioned by population, they immediately, and in the most insidious argument ever, try to all of a sudden count their slaves as people and try to say that those should count towards their representatives in the House.
Have your cake and eat it too, right?
Well,
Yeah.
and And the members of the Constitutional Convention immediately throw the red flag and go, there's not a chance. You don't give, like, treat them as if they're persons, and then you're going to try and benefit from it. So this is the sticking point for the South. The other clauses they signed off on, I don't think they realized how quickly they would be able to get rid of the institution under those other clauses. But this is the one that the South unifies behind. And basically what it says is representatives and direct taxes shall be apportioned among the several states which may be included within this union according to their respective numbers, which shall be determined by adding the whole number of free persons, including those bound in service for a term of years, and excluding Indians not taxed, 3/5 of all other persons. So essentially what they're trying to say there is that at the time the Constitution was signed and ratified, each free person counted as a person for the purpose of direct representation in the House. And they were counting slaves as 3/5, which is offensive. And we can certainly acknowledge that, and we should. But this is that one clause where the South flexed all the power that it possibly could to try to get behind. And that's the most that they could get done. And, that was quickly resolved. This is resolved within 90 years. It took a civil war to do so, but I think it's really important to recognize that the framers and these people in the convention, George Mason was a strong abolitionist. And
A Virginian abolitionist.
So was Patrick Henry. So there's a lot of voices in this convention that are fighting against this institution. And, they did. This is what we ended up with. It was a tough document to compromise on, but inevitably, ironically, with Gary, right? I mean, it's the power of representation that eventually is what kind of shifts that conversation.
Absolutely. And that's on that point, one of the most prominent things that Gary advocated for was what we call indirect representation. And I know that sounds a little bit abstract, but basically there's the difference between proportional representation, which is, how many people are in your state versus just an equal representation. So as we know our system today, every state has 2 senators, but then they have different numbers of congressmen or congresswomen based on how many people live in their states. So, and again, that was yet another compromise that was, hammered out during the whole convention. But Gary, for instance, wanted the House to be indirectly represented as well. And what that means is that the people that you voted for your state legislature would in turn choose the federal representatives, both House and Senate, according to Gary. So for most of the 19th century, what happened is that's how it worked for the Senate, is that whoever you voted for to be in your state house would choose your senators. Unfortunately, either good or bad, I don't know. Showing my colors here. The 17th Amendment was passed in 1913.
I'll come out and say bad.
Okay, bad. Implied bad, probably bad. The 17th Amendment did away with that process and just made it similar to how we do electing congressmen. But for most of the 19th century, it was indirect representation. So it was a very interesting, just historical phenomenon because there were definitely proponents of it, but in practice, it began to erode significantly from the 1830s onward, because what people would do is that the people would just informally vet their own candidates, and then they would submit these already predetermined candidates to the state legislature to basically just do a pro forma, okay, yeah, we'll just rubber stamp this. The most famous example of that in history of America was the Lincoln-Douglas debates. They weren't formally chosen by the Illinois state legislature, but that's what the people had selected for them, basically. Mm-hmm. So over the course of the 19th century, that process had whittled away until finally, in the progressive era, it was officially overturned with the 17th Amendment. Mm-hmm. And the reason why the three of us are kind of wincing about this is that I
haven't taken a position yet. Hold on.
Okay.
The 2 of us are wincing.
The reason why a more conservative and more of a states' right approach tends to favor indirect representation is that It provides better security against what Gary and his ilk would say it was demagoguery, but what we might see today as like being ruled by the coastal elites. It provides a buffer against being ruled by a big metropolis like San Francisco or New York when you live in rural Wyoming, that kind of a thing. We still have a similar version of that today in the form of the Electoral College, which I know a lot of people think is offensive because they think it's non-democratic, but the same idea plays out there of, well, with the system of electors, we make sure that rural, less populated places still have, a chance at being heard. They're not just drowned out by a big metropolis.
Right. And one of the most fascinating takeaways, if you read through Madison's notes on the convention, is that you really recognize that in 1787, democracy hadn't won out yet.
Yeah.
We hadn't decided that this was the way we were going to do things yet. So it's really fascinating. You see all these different theories of government going in there, because you're looking at, in 1787, the founders, when they look to history as their examples of republics are either A, small city-states that were immediately conquered by larger despotic regimes, or B, the Roman Republic, which fell into despotic empire. So they were very concerned about some of these direct issues. So there was all kinds of different theories, and these were the genius political scientists of their day. So you had theories like, okay, well, we can do the Electoral College, which is some sort of hybrid system between a popular vote and an appointment. You had Gouverneur Morris advocated for senators to be appointed directly by the president for lifelong terms. He wanted to create a literal American aristocracy. So you have these different theories. You have something you see in the convention occasionally is a sort of almost like pro-Stuart argument, Stuart-modern argument, where you have this situation where they're afraid of Congress and they want to empower the president. So Gouverneur Morris, for example, the reason why he wants a strong executive, he wants to empower the president over Congress, or at least as he says, is that what he's terrified of is a strong aristocratic Congress buying the votes and the control of the poor masses. And he sees the president in much the way the Stuart monarchs of England kind of represented themselves, as they're the one with the president would be there as a father figure to protect the common man from the avariceness of the landed elite. So you have this sort of this kind of anti-feudal argument for presidential power. You have pro-liberty arguments against presidential power. You have arguments for as much democracy as we can humanly get. You have people who are crypto-monarchists. So I think it's really fascinating.
Now David's just making up words.
But I think that's really fascinating, because if you look at the Constitutional Convention, you see a world in flux, and we forget how much the American Revolution and the Constitution changed the entire world, where democracy was very much an American experiment in 1787.
I think it's crucial to note on that point that the reason why people like Gary and Randolph and Mason didn't sign the original Constitution was that, and why they wanted the Bill of Rights, is that their grandfathers dealt with the experience of needing the English Bill of Civil Rights, and that was, they remembered, the use of torture and compelling testimony and not being able to have counsel at your show trial, and so this was very fresh in their memories.
Yeah, and so I want to respond. Before we do, remember, question and answer period will be coming up probably about 5 minutes, depends on how much more proselytizing we do. But so go ahead and click that button at the bottom of your page, says Q&A. You can submit any questions you have, and we will certainly get to those. But so I think you guys have said some interesting things, and I want to kind of just bring it out of we're getting a little deep. So I want to bring it up to a 10,000 foot view of, and then I'm going to immediately pivot to talking about Athens and Rome. That's the opposite of a 10,000 foot view. But so the framers saw the House as about as close to direct democracy as they were okay with, or that we could even feasibly have, right? So remember in Athens, you could quite literally go to the House, like to the parliamentary system that they had, and they would read the proposed law, and you could vote for it in person by yelling yes or no. Literally every citizen in Athens had a vote, and they voted on every major law.
How do you guys feel about casting lots instead of representatives?
Very different.
You just support? I think I might be a fan of that.
Yeah, I don't know about that.
I like the idea of Joe Plummer being the president.
Well, And so then here's the idea, right, is that is the purest form of just mob rule, right? That's about as, when you have that pure, direct, unadulterated democracy, you have mob rule. If you could, and we see it, and the founders saw it in Greece. If you could drum up enough passion, you could get anything passed. So the House is about as close as they were willing.
The term demos was not a good thing.
Yeah.
In ancient Greece.
So the House is about as willing as the framers were to get to that form. And the Senate is supposed to be the opposite. The Senate is supposed to be the more the reasonable check on the more passionate House. And the reason why it was then, it wasn't necessarily picked by the state legislatures. It was up to the states to determine how they wanted to pick their senators. At the beginning, almost every state said that they were going to do it via the state legislatures. So you get this, representative of a person, and it's further removed. And the idea was that they would represent the state's interest. The House represents the people's interest, and then the executive is the ultimate check on it.
Mm-hmm.
And so you get this very genius interplay of kind of, in our Republican form of government, of this, more direct democracy, more reason, and then it's all kind of checked out at the top. And I think that system and creates a lot of, I couldn't come up with something better today. Like,
right. I guess that's the question, because we're talking now and we're taking a bit of a deconstructionist approach to this. Mm-hmm. But think about it, because we're talking about the Constitution as this is a product of compromise and different men with big egos arguing with each other about different ideas, sometimes contradictory. But considering the fact that that's what it was a compromise, messy, drag-out argument of a document that only, 60% of the delegates even bothered to show up to talk about. But think about, what would a constitutional convention look like if we had today's leaders doing it? And you're like, we wouldn't get something better than the Constitution we have, not even in close. So I think that really tells you to the genius of those men, and also just the power of that moment in world history, which resulted in a sloppy compromise document being the greatest political document in human history.
Yeah, I wouldn't. I'm gonna fight on your sloppy word.
Okay.
I think it definitely was
I think the errata section at the end of the Constitution would beg to differ.
It was certainly a document of compromise. Maybe there are sloppy draftings, but that happens and things. But I think it was really genius. And a lot of people were able to flex power in areas that they really cared about, like Mason not signing the Constitution and holding out and refusing to ratify until there's a Bill of Rights. There are these really smart men who are fighting back and are flexing their power and are using their words to shape the system that we have. And it's, on the birthday of the Constitution, I think it's it's beautiful in a way. I mean, it really is. Are there, things that are a little nuanced in it? Are there some problems? Sure, absolutely. But I think you said it best, right? If we sat down today and tried to have, a new constitutional convention, I do not think that you get a system of government that protects and fights for natural individual rights like our system does, or like our system is supposed to. And, obviously, we're not necessarily living under a constitutional form of government right now, but it's certainly better than a lot of other governments around the world.
Absolutely. Yeah. So with that, I think I'd open it up for questions. And while we're getting questions from the audience, I think I'd like to start out with a question for you guys that I have, is that learning about Morris's questionable edits that he made, and other type situations like that, where you're realizing that the Constitution approved by the delegates was not necessarily the Constitution that was ratified. What does this mean for us as originalists, knowing that the Constitution isn't maybe quite the divine hand of God that we might have thought it was growing up?
So for me, it doesn't change much about how we practice originalism today. So when we are making originalist arguments, we're not just looking at the text of the Constitution, right? I mean, that's where we start. So I start at the text, I read that. But then what I do is I go and you look at, the debates at the Constitutional Convention. You look at letters that were written by different framers that had a hand in the different sections. You look at how they treated those sections, immediately after ratification. And I think those all inform your analysis. So I don't think it really changes it necessarily. If it was a pure textual conversation, I think it gets a little bit more problematic. But it's not in any sense of the word. I mean, we look at all of those other kind of founding era sources to inform our originalism. And I think it just, if anything, just highlights the importance of doing that, to me.
I mean, I'd have to agree. Every word in the Constitution was so thoroughly scrutinized again and again and again by some of the greatest minds in, frankly, history, that there is so much that you can unpack from just a single half a sentence. So I don't have much to add, really.
Yeah, 'cause I thought you guys would have more trouble with it. No problem. You don't think the Constitution is no less legitimate now,
Absolutely
having known
not.
this than you thought it was before?
Absolutely not.
Same. Works for me too. Absolutely. Like I swore an oath to protect and defend the Constitution, and that's the Constitution as ratified. So if it was good enough for the people, I may not agree with some of the edits made. I agree with some of them, but that's Constitution we have.
Yeah.
Okay, so we do question from the listeners. Number one, what do each of you think is the most important constitutional amendment?
Ooh.
Brian, you want to start with that, or who has an answer first?
Amendment.
That's
Okay.
Go.
Yeah. I mean, leaving powers to the state. We are a system of limited government, and that directly reinforces it. I think it's as simple as that.
Yeah, I think that's right. I think so the only question, right, is what's the most, what do we mean by important, right? Are we talking
Important
about
what? Yeah.
what should be first and foremost or what has been? I mean, obviously being the gun rights lawyer of the group, everybody expects me to say Second Amendment. And I do think it's very important because it's, our rights don't derive from the amendments. The amendment seeks to protect them from the federal government. And the Second Amendment is an avenue that we've been able to use to protect gun rights somewhat today. But I think you're right. I think the 10th is very important, and I think it should get more focus.
Mhm.
And I think the 9th. So the 9th Amendment is oft forgotten. And basically what the 9th Amendment says, right, is that, just because we've labeled 8 groups of rights ahead doesn't mean that there aren't other rights. Right. The 9th Amendment is the Natural Rights Amendment saying, look, by virtue of being a human being, you have certain natural inalienable rights. And just because we've deigned to protect these specific ones doesn't mean the others aren't protected.
I'm going to go outside the Bill of Rights.
Okay.
I'm going to do a 14th Amendment. This because 14th Amendment was, you could make arguments for incorporation before then people did. But the 14th Amendment is what brought the promise of American constitutional law to the people in practice, to a lot of people. I think that's very important. That's the 14th Amendment is the basis for most of constitutional law today. That's the basis for most of a lot of our lawsuits, a lot of constitutional lawsuits. That's the source where we get a lot of the protection from. And I think 14th Amendment has been misused in some ways. I think Clause 2 of all the Civil War amendments gives Congress a little bit too much power there. But I think the 14th Amendment is probably the most influential, probably the most important, because I could see a world in which the first 10 minutes weren't really all that useful, didn't really do a whole lot. That kind of the Madisonian argument that these are all implicit within our rights as Englishmen. 14th Amendment, that wasn't implicit. We needed that one.
It's the most pragmatic argument you've made in the last 3 years, probably.
I've been reading a lot of Gouverneur Morris.
It's on video, no less.
Yeah,
recorded live.
Okay, so that was a great question. Thank you. Next one. If the Constitution had not been ratified, what would have happened to America and to the states?
Ooh.
I want to tackle that one. So I think it's important to recognize that part of the historical context of the convention was that there was ongoing violence. There was, not necessarily at the same time, but there was the Whiskey Rebellion, there was Shays' Rebellion, there was the Carlisle riots in Pennsylvania. It is remarkable that we didn't boil over into a civil war in the 18th century. And the fear of torches and pitchforks and mob rule on one side versus, out of touch aristocrats imposing serfdom in Virginia or something like that. That was a very real fear among all aspects of American society at the time. And the fact that over the course of the summer, basically, they were able to avert that is, profound.
See, I think about this a little bit differently. And I really do wonder. So what we did, right, is we just abandoned the Articles of Confederation and just instituted a wholly new system. I wonder if there could have been a better middle ground. The Articles were very much focused on states' rights, on very little federal government, federal control, but the Articles did lack a certain amount of teeth, right? I mean, they couldn't forcibly collect, the federal government couldn't forcibly collect revenue from the states in order to pay for the military when it needed to, which was Washington's chief concern. But I wonder if there could have been a middle ground between the Articles of Confederation and the Constitution, where you can imbue some of the important clauses and articles that you get in the Constitution into the Articles of Confederation. So that would be the only question I would have. And it's really hard to play alternative history, and who knows what that looks like later on. But that would be the one thing I'd say is we did have a system of government before the Constitution. And I think we might have been able to repair some of the flaws with that instead of kind of throwing away draft one and writing a whole new version.
Yeah, I'm really not sure what if the Constitutional Convention had gone down in flames on September 1st and everyone had gone home. Would we have collapsed in civil war? Would they have tried again the next year, gotten something a little bit different?
Yeah.
Would the energy of the moment be gone, and we would be 14 individual states that slowly got gobbled up by European imperial powers? I don't know.
When that was their biggest concern, right? That was their biggest concern, was that they had just fought a war for independence. We had just declared ourselves a nation, and then
join or die.
Immediately thereafter would devolve into a civil war. And the Constitution prevented that. So I think that's important.
And I'm being told by Nathan that I need to give a little bit more info on the 14th Amendment. For those who may not be aware, the 14th Amendment, my pick, is that was after the Civil War. It was called the Civil War Amendments. The 13th, 14th, and 15th Amendments ended slavery, extended equal protection of the law to all Americans, particularly to the former slaves, Black Americans, and then provided them the right to vote in the 15th Amendment. So that's what that's about. It's often been referred to as the one that incorporates the Bill of Rights. So it basically extends the federal protections to the states, because after the Civil War, was a situation where you had the state governments that were not living up to their obligations under the American system.
Mm-hmm.
So that's what the 14th is about.
And by incorporation, what David means is that essentially what incorporation is the Supreme Court has held that the 14th Amendment, oftentimes the due process clause of the 14th Amendment, which grants due process and equal protection of the laws, also means that the various amendments apply to the states, not just the federal government. So when you hear of somebody bringing a First Amendment or a Second Amendment claim against a state government, oftentimes the way that they're doing that is via the 14th Amendment. That's what we call incorporation. Before that, it was very difficult to try and bring certain lawsuits against the states because a lot of those amendments say, Congress shall make no law. But does that mean only the federal Congress, or does that also mean the state Congresses? And prior to the 14th Amendment, in most cases, that meant it was just a restriction on the federal government.
Like an example from history is before the 14th Amendment, if a state took your property, you couldn't say, hey, the state of Massachusetts violated the Fifth Amendment. I demand this is a taking because I want just compensation. No, there's a famous Supreme Court case saying, no, the Fifth Amendment only applies to the federal government, not the state government.
You could only do that. You couldn't do that until Dick v. Scott 2
Yeah.
years ago.
Right.
Next
webinar.
Yes. next question. How has the role of the Supreme Court changed compared to what the founding fathers originally envisioned?
Oh,
Which founding fathers?
that's an interesting question.
This is actually one of the big debates is judicial review, the right for the Supreme Court to say this violates the Constitution. Whether or not they have that power or not has been up for debate since the convention.
Yep.
So I think it really depends. I think if you ask someone like Madison or Gouverneur Morris, for example, I think you would find they would say that the Supreme Court hasn't really changed all that much. I think they would see it as the Supreme Court's operating more or less how they always expected it. You talk to someone like Thomas Jefferson, you're going to get a very, very different answer.
And the fellow who's responsible for this doctrine, John Marshall, Supreme Court Justice, another fan of a strong central government. And when you're a law student and you read you're like the first day of your constitutional law class as a first-year law student is Marbury v. Madison. So it was case law that developed that doctrine, really, and made it explicit. It's not in the Constitution.
Yeah, and you're talking about, and that's the open question, right?
What is the judicial power?
Exactly.
And you're talking about a case that was decided in 1806, 1803?
1804.
Oh, well, I could just bookend it. The early 1800s, but so it's not all that far after the Constitution being ratified, right?
But also, Marshall was an active partisan in that debate.
Right.
Well, but I mean, everybody, we could do a whole webinar on Marbury v. Madison. We really don't want to dig into it, but I think that it is very closely decided, and it is an interesting question. And basically what we're saying to whomever asked it is thank you very much for asking it. And maybe next webinar, we'll have an hour conversation about the judicial power. I think that is a really tough question to answer because there are conflicting viewpoints of the framers on that question.
And I think that's actually a really great question to go out on because it's talking about, it really highlights the fact that Constitution is complicated. Understanding it's difficult. It requires a lot of work. There's a lot of people who had a hand in it. They had different goals, different ideas, and trying to figure out what it means, which is vital to our work and vital to the survival of the Republic, in my opinion, is a difficult undertaking that we need to take very seriously.
Absolutely.
So thank you all for coming on this fine Constitution Day. We really appreciate it. You can find this video will be up on our Facebook and I believe our other social media shortly. Please visit our website, mslegal.org. We also have a Twitter account. And do we have an Instagram yet?
I think we do. We have
an Instagram. So we are on the socials. We are very 21st century.
We're young. We're hip.
Modern. Yeah.
Influencers.
But thank you again, everyone, for coming. We really appreciate it and have a happy Constitution Day.